Good morning to folks in the Americas and welcome to those joining us elsewhere. I'm Pat Holohan, Managing Editor of the Bankruptcy team here at LevFin Insights, or LFI, and I'm thrilled to be hosting today's webinar and podcast. 2025 was a very busy year for bankruptcy, highlighted by First Brand's collapse into Chapter 11 and the Chapter 22 comeback cases of Rite Aid and Spirit Airlines. But now that we're nearly 3 months into 2026, we wanted to assemble a panel of experts to explore what we're calling hot topics in bankruptcy for the first quarter, looking at a few different interesting cases and developing situations. First, we'll discuss highlights from the Creditor Opportunity Symposium hosted by the Creditor Rights Coalition at NYU last Friday. It was a very well-attended event, bringing together a couple of hundred practitioners, academics, and students to discuss important issues facing the credit markets and the restructuring community. Next, we'll check in on the world of LMEs and see what's developed in out-of-court debt restructuring so far in quarter one. And then we're going to look at a few recent Chapter 11 cases of note. First, we're going to look at OPI, Office Properties Income Trust, including a recently resolved lawsuit over an original issue discount, Multicolor, a highly contentious case that has led LFI bankruptcy coverage by a number of stories so far this year. Serta Simmons, which I think folks have been following for quite a long time. But finally, post-bankruptcy litigation there started trial earlier this month and will return for closing arguments next week. So we're going to see what's going on there and what might be a likely outcome. And finally, we're going to discuss the state of the law on third-party releases and ever-evolving Feng before we move to audience Q&A. We recognize that there are a lot of issues of interest in the restructuring community right now, especially cooperation agreements come to mind. And we're going to do our best to address as much as we can, but for the purposes of a 1-hour webinar, we had to narrow things a bit. I'd like to start now by introducing our great panel. First, to my right on the virtual screen, you'll see is Mark Lightner. Mark is the head of special situations legal research at CreditSights and our resident bankruptcy expert. Next to Mark is Ian Feng. Ian is a senior covenant analyst at Covenant Review and a recognized expert on liability management exercises. For those of you who don't know what Covenant Review is, it is the market-leading expert on bond and loan covenants. It's a Fitch Solutions company that sits under the umbrella of CreditSights. Next to Ian is Raf Ferrioli, a partner at Morrison Foerster, whose work includes representing unsecured creditors committees in the Chapter 11 cases of Del Monte Foods, Saks, Incora, and others. Finally, next to Raf, we have Mark Heimowitz. Mark is founder and managing member of Coda Advisory Group and a founder of the aforementioned Creditor Rights Coalition. Mark also recently served as the court-appointed examiner in the Chapter 22 case of Spirit Airlines. Now, before we dig into the agenda in earnest, I wanted to address a few housekeeping items. If you're joining us live, you can submit questions at any time. We have a large audience. We're going to do our best to get to all the questions we can. If you have a question that we don't get to today, we will follow up offline later today or tomorrow. We are happy to share this slideshow with anybody interested. Please reach out to us directly or email our events team email address on the registration page. I'll note today's webinar is being recorded and will be available on YouTube. We also recommend subscribing to the CreditSights YouTube channel, which includes recordings of dozens of webinars and podcast episodes. This recording will also serve as this week's episode of No More, Risk Better, the CreditSights flagship podcast. It's available wherever you listen to or watch podcasts, including YouTube. Finally, if you'd like more information about our bankruptcy coverage, which we recently expanded earlier this month to include all companies with at least $100 million in funded debt, feel free to reach out to me and my colleagues. Now, let's head to the agenda. I would like to talk to Mark Heimowitz first to give highlights from last week's Credit Opportunity Symposium, which featured panels on managing credit risk across the corporate loan market, LMEs, free fall, and fraud in Chapter 11, among a few other topics. My colleagues Ian and Mark Lightner and I were able to attend the event at NYU, and I was hoping that Mark Heimowitz, who gave the conference closing remarks, to give us his takeaways and themes that came out of the conference. Mark?
Sure. Thank you very much. I appreciate being here, and I'm happy to recap the Creditor Rights Coalition conference. On Friday, March 13th, we had our fifth annual conference. I think it was the most successful yet. And it's done in conjunction with the LSTA and NYU Stern Business School. We had over 300 attendees. Our attendees, as usual, come from a whole host of senior people through mid-level people all the way through students, a very high quality class of attendees. And they represent a good section of the 3,700 member subscribers that we have at the Creditor Rights Coalition, including market participants across the buy side, the sell side, including aggregators, as well as many attorneys, judges, financial advisors, industry media such as LevFin, and academics. There were really three themes that came across in our panels. We had 6 panels and a keynote presentation. And sometimes you just get very lucky in time, and you get very lucky in terms of having coherence of themes. And this was one of those times. We had really 3 themes that crossed over all of the different panels. The first was discussion of credit risks and opportunities across the loan market, including the exposure to software-related issues, which of course is a hot topic. You know, what is the SaaS apocalypse going to do to private issuers and to public issuers? And fraud, including a robust discussion of the double pledging issues in First Brands and Tricolor. And what I haven't heard for 20 plus years, the term cockroaches, as the number of fraud cases that are known may be multiplying underneath those rocks as more fraud cases. And a discussion of private versus broadly syndicated loan markets in particular, and I'll get to that more in a moment, and idiosyncratic versus syncratic risk, systemic risk. That was one theme, and it across all of the different panels. Another was, of course, a discussion of LME's past and present trends and sponsor reactions and ability and use of new tools to force LMEs or allow for additional LMEs, and then the reactive responses of creditors in the form of cooperation agreements, omniblockers, and potential other tools. And that was really very related to the first issue on credit risks as well, because a lot of the discussion was about documentation risk and how the bank markets themselves have changed. And then third, we had a theme that was based on artificial intelligence. And I'm pretty proud that we got this into our conference. We haven't seen it in many conferences. And we had a wonderful presentation by Vasant Dar, who is the author of Thinking with Machines. And he kind of laid out the whole paradigm shift of AI becoming a general purpose technology like a computer and what that's actually doing for our markets in particular. And had a long panel about how money managers and money aggregators and generally speaking, the analyst and sales and trading communities are using AI to really change how they're operating and managing risk and opportunities. So I'll give you a couple of takeaways, and they're listed on the slide here in no particular order. But one thing that was very apparent to me is that the bank and loan markets have flipped position with the high yield market. This is not the 20-year ago bank and high yield market where banks were multilateral or bilateral loans, or even the bank markets where you had a 1L, 2L, and an asset-backed facility that all were secured with the high yield being the fulcrum security. The bank markets are now actually more risky than the high yield markets if you just look at the level of rating and the expected default rates. They include much more in terms of PIK instrumentation. They have much more documentation risk. One very interesting takeaway from the conference is that it is the same institutional base that is investing now in private markets as in broadly syndicated loan markets. 2 years ago, we had panels which focused heavily on what are the differences between the BSL market and the private markets. Last year, we had panels that sort of followed up on that. This year, what was notable was that no one cared. There is no real difference between those two markets in terms of how people are investing. Of course, there are differences in those markets. Private markets and loans documentation tend to be stronger than in the BSL market, but they also tend to have higher sector concentration, opacity with respect to both credit quality and with respect to marks. And they also have liquidity concerns that all of the people on this call are probably aware about in terms of redemptions and being able to meet in oftentimes a retail redemption, but even just an institutional redemption as well. But one thing that did not come up again is that the underwriting is all that different. And the S&P panelist who rates CLOs was very clear that even in private structures, S&P and others can get access to underlying credit information. There's not much of a difference anymore. A second big takeaway is that document risk is much higher for loans than for bonds. And perversely, the complexity is causing both more LMEs and allowing for more fraud. The complexity and the breakdown of what are usually single stack UCCs into very, very complicated up tier structures, drop down structures, and other structures that allow for a lot of invested capital to be put into place without great oversight are leading to some of these tricolor and first brands issues, and are also leading to an enormous amount of LME activity there. High yield bonds are ironically concerned with incurrence tests and maturities, and in some ways are being left out of all of this action with respect to LMEs. LMEs, of course, have existed forever, but they've generally been between classes. And the stuff that we're talking about is really non-pro rata or pro rata issues within a class. And those classes that we're talking about are bank loans because it requires the complexity and the use of language in the contracts in order to achieve an LME. We also found that contracts are basically being resolved, or the LMEs are being resolved according to contract language itself. They're not being resolved ex ante. One theme that was pervasive here was that money aggregators are still concerned with putting money to work and are not actually resolving open issues in language or forcing function with respect to things like Serta issues or other LME type of exposures. And they're letting someone else to do the workouts. It's essentially a not my problem. LMEs will continue to come down to contractual language. They've been mildly less aggressive in 2025. In the second half of 25, about 50% of the up tiers were pro rata as opposed to 40%. But the sponsor toolkit remains really strong. You have DQ list, disqualified list, you have voting caps and control over amendments. And then on the other side, you have anti-cooperation agreements, with optimum, of course, being a big case to be decided. And then a discussion of Xerox was also had, which is just another opening front on the LMEs about using the definition of subsidiary and seeing if you can squeeze an LME in through a subsidiary definition exclusion for a joint venture. And then finally, with respect to AI, the adoption is accelerating. The firms can run their businesses with fewer people. There are, of course, overlaps and interactions with software type credits. What is AI going to do there? But in terms of actually the business that money managers are in, money aggregators are in, analysts are in, no one really knows how deeply this is going to affect how the business operates. But it's going to be significant, and uncertainty is really the hallmark here. No one knew, but not very many people thought that it was going to be at the level that we're at right now, and uncertainty may or may not be priced in. I encourage anyone to look at the full agenda, which along with written presentations is at creditorcoalition.org. We also send out a weekly newsletter, and it's read not just by our 3,700 member subscribers, but it gets more broadly circulated. And we cover a lot of these issues and have contributor selections as well. So I'll turn it back over, but that's a summary of what we did on last Friday, and it was an exceptionally successful conference in our view.
Thanks, Mark. Agreed. It was really nice to be there and hear everybody. I'd like to move now to my colleague, Ian, the resident LME expert. Ian hosted a panel at CRC on recent developments in LMEs, and also last year put together a great presentation to educate all of his colleagues here under the CreditSights umbrella of what's going on. Ian, I know you're instrumental in putting together our quarterly report and year-end analysis of all LMEs that take place in the market. So what's happened over the last few months, specifically first few months of 2026?
Thanks, Pat. Before we jump into Q1, I think a quick recap of 25 is worth doing. And that's just to show you that LMEs are very active in both 2024 and 2025. In both years, we saw around 50 transactions each. There is, of course, a caveat here, which is that there is no formal definition of LME. So depending on your source, those numbers might shift slightly. But at the same time, I think we all understand that out-of-court restructuring is completely a established trend now in this year, 2026. So thus far in 2026, we've tracked around 6 LMEs, and I imagine that number will change before the end of the quarter. And of course, it's subject to that same caveat. Major LMEs in Q1 include, of course, Xerox, Rinchem, Vibrance, and CSC ServiceWorks. Looking forward, we expect LME activity to continue, and perhaps a better metric would be from my colleague Evan Dufault at LFI, who curates a restructuring runway report. For March 2026, he tracks 46 potential LMEs in the near term. So these are 46 companies where we expect a restructuring or some other activity from the restructuring front to occur. Of course, there's going to be your standard names with the SaaS apocalypse. So software names, tech names, as well as construction names. Oldcastle, Building Envelope, Jeld-Wen, and Cornerstone are all names that are being bandied about as potential LME candidates in the next couple of weeks or months. On the post-LME landscape, what we're looking at is 3 possible consequences. And what I'm really talking about here are for transactions that for companies that conducted LMEs in 22, 23, 24, and even last year, there's an expectation that they're going to be facing an additional pressure to do something in the next couple of months. And that's because LMEs ultimately are a purely financial transaction. They don't do anything to address the fundamentals of the business. As such, if the company does an LME in 23 or 24, unless they've turned the ship around, they're probably facing all the same kinds of pressures when it comes to the need to do a restructuring. The chart on the right is done by my colleague, Steve Miller at Covenant Review, and it's a great chart because it shows you covenant flexibility pre and post LME. Pre-LME, there's a lot of flexibility in covenants. If you've been paying attention to the BSL market or high yield market, you know that covenants allow for a lot of room to maneuver. Post-LME, that gets shut down to a large extent. So the ability to do additional LMEs becomes very difficult. Now, there's a couple considerations here. For companies that did deal away LMEs that didn't modify existing covenant packages, a second transaction is still possible. So think Astound Broadband last year, for example. However, what we expect is an increase in Chapter 11s as a result of this chart on the right, which is that the company is lacking in flexibility to do the kind of creative maneuvering that allowed for that first transaction. And we've seen that happen already in Q1 with 4 Chapter 11 filings in this quarter alone. So Saks, STG, Pretium, and Cumulus. There's also a third possibility, which is handing the keys to the creditors or equitization. And we've seen a couple of instances of that as well. And at the CRC conference, we talked about potential stock in the box type provisions, which are provisions that are built into LME documentation designed to hand the keys over to the lenders if the company fails to meet certain milestones. And then on this next slide, I'm just going to touch on a couple of key LME topics that we've also observed in Q1. There's been some litigation points that are worth discussing. STG, again, is a case that was closely watched by the market last year. Minority creditors had sued the company as well as the participating lenders in that particular liability management transaction, and they actually survived the motion to dismiss earlier this year. Now, the judge there did seem to have, at least in my opinion, a sympathetic view towards the minority lenders' arguments. And there was an overall pragmatic approach towards reading the credit agreement. Of course, STG filed for bankruptcy shortly after that motion to dismiss was itself rejected by the judge. So unfortunately, I don't think we're going to see any sort of decision on the merits anytime soon on that particular case. As mentioned, co-ops are continuing to be a major theme for LMEs in Q1 as well as last year. Optimum Communications' ongoing lawsuit saw some movement in Q1 in particular. The defendants filed for a motion to dismiss, and Kirkland and Analyst, of course, stepped down as Optimum's counsel. We also saw anti-co-op language sneak into the private credit market of all places, and this was reported, I believe, by Bloomberg. The case was Majesco. The deal was Majesco, and at least as reported, it's slightly less aggressive than what we've seen in other anti-co-op provisions, in that it only required reporting of the formation of a co-op, as opposed to outright prohibiting a cooperation agreement. So we'll see if that kind of softened anti-co-op language is going to sneak its way into broadly syndicated loans as well. And as Mark mentioned, the game of whack-a-mole is continuing in Q1, as illustrated by Xerox. So lenders are putting in blockers designed to protect against the risk of particular LMEs. Sponsors are finding ways to bypass that. Those blockers are being iterated upon, and additional workarounds are being developed. So we're going to continue to see that, I think, throughout this year, and that's always been the case for liability management. Pat, I'll turn it back to you so we can do our first audience question.
Yes, I was just going to say we like to keep these interactive. Where do we see post-LMT names predominantly headed in 2026? Bankruptcies, recaps, or second-round LMTs? I'll say for myself, I like being busy and being employed, so I personally can't help but root for some bankruptcies, but I'm curious to see what everybody might think in the audience. So we'll give that another second before we move on to our next topic. But Ian, it's always great to get LME perspective from you and Mark on the CRC conference. It's funny, so many names and faces you see from being on 10 million Zoom calls a year in court and elsewhere of, oh, that's a judge, that's that lawyer. It's it's a big community, but also relatively small in terms of the same faces you kind of see going around and around, which is nice. All right, let's see what we got. Oh, it looks like, all right, I win. Bankruptcy is 48.6%, recaps 25.7%, and in the tie with second round LMT. So most people think bankruptcy. Let's look now and go to our next case. I'd like to speak to the other Mark on the call, Mark Lightner, our expert on bankruptcy here at CreditSights. Office Properties Income Trust entered bankruptcy in October 2025 with an RSA, but immediately filed a lawsuit to resolve a question over a $70 million original issue discount. That lingered for about 3.5 months. Case finally broke out last week. There is a settlement that will give this group of 2027 note holders that had been subject to litigation, I believe, $60 million in cash, plus 300 plus million promissory note to resolve the rest of their claim. It's been a very interesting case to follow, but a settlement means no decision from the court, leaves a number of questions unanswered. Mark, what are your thoughts on the issues raised specifically by this litigation?
Thanks, Pat, and good morning to everyone. And as always, it's a pleasure to be here. As Pat mentioned, I'm going to talk about Office Properties Income Trust. It's a Chapter 11 case. I'll refer to it as OPI or the debtor. And like the 48.7% of the group, I also voted for bankruptcy. So this is a case that resulted after a failed LME, as Pat mentioned. And like Pat mentioned, I don't want to be accused of bearing the lead. This litigation did, in fact, settle. So we don't have a judicial outcome or guidance on the specific issues raised, but we still believe that this is a really important topic for the bankruptcy community writ large. We also wrote on this topic in the middle of July, and it was one of the top read reports across our platform for a period of 30 days. So the restructuring community, the law firm community is very attuned to this, even though we don't have a judicial outcome. So let's get into what happened in the OPI case. So OPI is a debtor that was a REIT that owned approximately 124 office and mixed-use properties across the majority of the United States. The primary tenant of the debtors was the United States government. And the debtors faced a maturity wall in 2025. So, like many debtors over the last several years, they attempted an LME the year prior to their maturity wall in 2025. And we put the details of that 2024 LME transaction here in the slide. But the gist of it is approximately $282 million of those 2025 unsecured notes, that was their maturity wall, agreed to exchange and provide additional liquidity to the debtor to the tune of approximately $58 million. So that's the consideration the creditors gave up as part of the exchange. In receipt, as part of that exchange, they received $445 million in 2027 secured notes, plus they received some equity in the debtor, as well as some cash consideration, including premium payments and some cash in the form of fees and the like. And at least according to the debtor's calculation, that generated approximately $135 million in original issue discount, or OID, resulting from the exchange offer itself. And so, as Pat mentioned, OPI filed for Chapter 11 at the end of October in the Southern District of New York. The Southern District of Texas, Judge Lopez presiding. And immediately thereafter, the debtor commenced an adversary proceeding against those exchanging holders, effectively to put a lot of pressure on them, seeking disallowance of that $135 million OID component of the exchange offer. And so the central issue that was teed up in that case is whether that $135 million of OID should be disallowed as unmatured interest under Section 502B of the Bankruptcy Code. And so before I get into the parties' arguments, I think it's worth spending just a couple of minutes to set the table in terms of what the law is on that. We have a large number of people here. I expect many people who are listening in have great familiarity with some of these legal issues, but just to set the table a little bit, I'd like to spend just a couple of minutes talking about that. So the Bankruptcy Code disallows "quote unquote" unmatured interest, but unmatured interest is not a defined term of the Bankruptcy Code, but it furthers the policy that we don't want to pay creditors post-petition interest because we want to fix the claim amounts of creditors as of the petition date so that estate value can be equitably distributed in accordance with the priorities established by Congress. So the courts have uniformly held that unamortized OID is the functional equivalent of unmatured interest. So we cut off the payment or the accrual of OID as of the petition date. And there's very little controversy with respect to that statement. Most courts are in congruence on that issue. There's some nuance in terms of how we calculate the unamortized portion of OID, but generally speaking, there's no issue with that particular proposition. It gets a little more complicated when the OID that we're talking about arises in the context of a pre-petition transaction, either in the form of a pre-petition exchange offer or a pre-petition LME transaction, such as what happened here. And so going into this case, there were 3 precedent cases that kind of painted the picture of what the case law actually says in this area. And so there are 2 circuit level decisions from the early 1990s, one out of the Second Circuit in a case called In re Chateauguay, and one out of the Fifth Circuit called In re Pango. And both of those cases stand for the proposition that when a debtor engages in a pre-petition exchange offer and the principal amount of the outstanding debt remains the same in the pre-petition or the pre-exchange and the post-exchange, any OID that's created as a result of that, because if you extend out the maturity, there may be OID that's created as a result of that, will not be disallowable OID for the purposes of bankruptcy claim allowance under Section 502 of the Bankruptcy Code. And the Second and Fifth Circuits describe those as face value exchanges. So there's precedent at the circuit level that says those kinds of exchanges don't create disallowable OID for purposes of bankruptcy claim allowance. Fast forward almost 20 years, in 2013, the Southern District of New York Bankruptcy Court took that rationale and extended it one step further in the case of residential capital. And in that case, bankruptcy judge Martin Glenn basically said in a nutshell, if there's a pre-petition exchange offer and the value of the debt changes or goes down as a result of that, we're not going to create OID in that case either. And we call that a fair market exchange. So if the principal amount goes from $1,000 to $800 as a result of the exchange, we're not going to create OID for disallowance purposes under the bankruptcy code. Okay, that's the state of the law going into this litigation. We've got those two circuit case decisions that talk about no OID from face value exchanges, and we have Judge Glenn's decision that says no OID for fair market value exchanges. That's the state of the law. So we go into this case, right, and OPI, as the plaintiff, says, wait. Neither of those cases are applicable here because in the LME transaction at issue here, right, the exchanging holders didn't get the same face amount in principal. They didn't get a lower amount in principal. And instead, one of their forms of bargain for consideration for that exchange offer is they got a lot more principal. And so therefore, all of those cases, all of those propositions don't apply in this context, and we should apply the traditional OID rationale that I mentioned earlier and disallow those claims as OID. And this is important, right? So this case sets up because, as Ian mentioned, there have been a lot of what we'll call new LME type structures that have occurred in the last several years, and a lot of them have OID as a component. And so you have to think about, well, is that OID component subject to potential disallowance risk in a potential bankruptcy? So this is a really important issue for people in the OID in the restructuring community and to understand OID. So in addition to the argument that the plaintiffs made in that case, which is basically like none of the precedent cases apply, one, two, this increases the amount of principal, so therefore the traditional OID rule should apply. They also said, if, judge, you allow this to occur, you're actually allowing creditors to extract value from debtors in the pre-petition period, which is contrary to the whole purpose of an out-of-court restructuring. So that's what the plaintiffs argued in that case. The defendants, on the other hand, came up with a whole slew of very creative arguments, several of which are beyond the scope of today's discussion. So I'm not really going to get into them. But the primary argument that they say is that, look, the precedent cases are very clear. Any OID created from a pre-petition exchange offer is off limits for disallowance in bankruptcy because it furthers the goal of out-of-court workouts in the pre-petition period. That's their main focus. And this case, like I mentioned, was commenced early on in the Chapter 11 case of OPI. The case settled under a mediated resolution under the auspices of Judge Itzger in that district. So I guess that's a good thing, right? So we always favor mediated settlements in bankruptcy cases. Unfortunately, we don't have a judicial outcome. So these issues have been teed up. We've provided a roadmap to future litigants. So potentially in future LME situations that find themselves into Chapter 11, we have a perfect roadmap for how to litigate this issue going forward. However, there are a few things that we can take away from this that are instructive and that are helpful for us to think about these issues going forward. So UMB, which is the trustee for the note holders, filed a claim for $426 million. And as Pat mentioned earlier, the settlement provided that the creditors received $60 million in cash plus $335 million in secured take-back debt. And the settlement agreement term sheet required the debtors to sell property to satisfy that obligation over time. But that's really beyond the scope of what I want to talk about here, which is basically to say that the creditors took about a $30 million haircut on their stated claim amount versus what they settled. And if you take that $30 million and you compare it to the $135 million of OID that the debtors at least alleged that the creditors would be entitled to, you're looking at a roughly 25% discount from the amount of OID that the creditors, at least the debtors thought that the creditors were entitled to. So you're looking at about a 25% discount. And I think that that's indicative of, setting market expectations of how a mediated resolution for this kind of issue could be resolved on a go-forward basis. So that's a really important data point. And it's also, I should note, in closing, it's entirely consistent with the types of mediated settlements we see in post-LME issues that show up in bankruptcies, like in double dips and the like. So I'll pause there. Super interesting case. I fully expect this issue to come back at some point in the not so distant future, and we have a perfect roadmap set up here.
Thanks, Mark. Got another question for everybody, the interactive portion. Do you expect the OID disallowability issue to reemerge in future bankruptcy cases involving LME-style exchanges? Yes, no, depends, uncertain. Mark, I think I specifically remember when this case happened, we were talking, I think the first day of the case, saying this is going to be a whole thing. And it was, I was starting to get excited for a trial next month. We'll take a settlement, but I'm really interested to see this popping up again.
Well, and
sometime.
anecdotally, one of the big cases I worked on when I was a very junior lawyer was residential capital, representing the Suns in that case. So it definitely kind of full circle, if you will. And by the way, I should note, while we're still waiting on a few audience poll questions, feel free to reach out to me if you would like a copy of that report. If you haven't already received it, it's available across all our platforms, and it's also available on our website if you just give us your business email address and contact information.
Right, so we'll see. The yes is the winner. So far from our audience, we're looking at yes, more bankruptcies, yes, more disputes. Love to see it. So let's move on now to Multicolor, which I mentioned before has been the most active case for us so far at LFI Bankruptcy this year. Anecdotally, I was stunned when I was doing my research and putting together information on this to see they filed less than 2 months ago. I would have told you 6 months ago based on what's happened. But Multicolor filed for Chapter 11 in New Jersey nearly 2 months ago with an RSA. Despite that RSA, the company has big battles going on with an excluded group of first lien lenders and a second group made up of crossholders. Notably, so far in the case, we have an appeal of the interim DIP order. There was a final DIP hearing yesterday that has been kicked to continue next Monday, the 23rd. And I think extremely interesting, there was a failed effort to get the case moved to Delaware. Raf, a lot going on in this case. Can you give us some of your thoughts?
Absolutely. Thanks so much, Pat. So Multicolor, I think it's an understatement that this has been a very active case for those of you who've been following, particularly over the last few days. I think it's also true that looking at the amount of docket entries and activities and appeals, it is sort of surprising that this case filed just on January 29th. So we did hope to have a firm update on the DIP, but as Pat mentioned, that full day trial yesterday is ongoing. It's been continued until Monday, the 23rd. So there's more to come on that, but it is a really interesting case. Again, it filed on January 29th. It's a pre-pack. It's supported by, I think at this point, over 80% of the company's first lien lenders, as well as the sponsor CD and R. The majority 1L ad hoc group under the RSA is providing a DIP. It's a $657 million DIP facility. Consists of a number of features, including $250 million in new money and a roll-up of $250 million. 30% of the commitments are allocated to the DIP backstop parties on a pro rata basis, and all of the first lien lenders can participate in the remaining 70%. Now, there are two ad hoc groups, as Pat mentioned. There's a group of what I'll call excluded first lien lenders, and then a second group of crossholders. The excluded first lien lenders, they objected to the DIP. They argued that the roll-up provision, among a number of other features, improperly disadvantages them, violates the pro rata repayment provision of the debt documents, and there was some activity on that at yesterday's hearing. The second group, the crossholders, they've also objected. That's the group that appears to be leading the charge in challenging multiple aspects of the pre-pack, including the appeal of the interim DIP order and a lien challenge that was also filed. The crossholder group made a competing DIP proposal. It was $500 million of new money. There was no roll-up, and overall, the DIP was less expensive. They've argued that, basically, look, we have the better proposal. This DIP, this RSA is an inside job. It's engineered to favor the first lien lenders and the sponsor. Now,
as we mentioned, trials ongoing. The debtors have argued, and I think some testimony came out yesterday, that, at least from the company's perspective, that the cross-holder proposal, although perhaps less expensive on paper, was a path to nowhere, to use, I think, to frame this the way that the debtors would prefer, because it did not contemplate an exit and basically would have resulted in a free fall case. Again, the cross-holders have been challenging the pre-pack from a number of different angles. Remains to be seen what happens with the dip. But one of the more interesting challenges was to venue. And just 2 days ago, we had a decision on that. So the crossholder group moved to transfer venue or dismiss the case. The United States trustee filed a complementary motion, basically seeking the same relief. And it's an interesting angle to attack the case, but I think for all of us who practice in the bankruptcy court, it's not surprising. I think those of us particularly who represent creditors or are creditors in cases often find ourselves appearing and filing pro hoc vice motions in jurisdictions that, at least at first glance, are not where we might have expected a bankrupt or debtors to file a bankruptcy case. And here I think is no different. So the company is an Atlanta-based company. They filed in New Jersey. And the debtors relied on MCC Norwood, which is one of their subsidiaries, an Ohio company, as being appropriately filing their petition in New Jersey as the hook for venue for all of the other entities. This debtor has no operations, had no employees. It was basically a dormant box. So what the debtors did here was in December, so just over a month before the petition date, they opened a bank account in Englewood Cliffs, New Jersey. They ultimately funded that account on January 13th, so just 16 days before the petition date, with just over $1 million, their adequate assurance deposits. They had a second bank account that they opened as well. They funded $1,000 in that account and basically argued that this entity's principal assets for the venue look-back period, the 180-day period before the petition date, were these two bank accounts. Now, the arguments here, there were a number of arguments that were lodged, but I think, in some, basically, MCC Norwood, part of this enterprise, is an Atlanta-based company. Their principal place of business is being in Atlanta. Nobody's disputed that. The movements also argued that this entity possessed other assets that were outside of New Jersey that were more appropriately principal assets for purposes of the venue analysis. In framing the dispute, and before we get into Judge Kaplan's decision, I think it's important to just spend a moment on the statute. It's very broad, and it permits a debtor to basically file in any district where its residence, domicile, principal place of business, or principal assets were located during the 180 days preceding the petition date or for a longer portion of that period. The bankruptcy court, in ruling on this and deciding these issues, basically framed the question as twofold. First, we have to look to what are the principal assets, and then second, where were those assets located during the 180-day period? Judge Kaplan, the decision is almost 30 pages, and I think it's a very well written and reasoned decision. And he goes through some of the tests that courts look at in determining whether a venue selection is appropriate. There were two tests here. First is the time-based approach, and second is the asset-based approach. Under the time-based approach, the debtor's principal assets are identified, and then you tabulate them for each day during the 180-day period to determine where the principal assets were located for purposes of venue. So here we had bank accounts. They could only serve as principal assets for 16 days because they were only funded for 16 days before the petition date. If there were other assets held for longer than 16 days during the remaining 164-day period, if my math is right, those assets would be the debtor's principal assets under the time-based approach. The second test, the asset-based approach, looks to what assets the debtor had on the petition date and where those assets were located for the longer portion of the venue look back, that 180-day period. Now, this test is both quantitative and qualitative. So where debtors have multiple assets, the court would need to determine both what the assets are they principal, and where they're located and for how long. Judge Kaplan adopted the asset-based approach. I think that in a world of imperfect tests and a broad statute, his reasoning was basically that this is less likely to result in an absurdity in selecting venue because you're actually focusing on what the assets the debtor had on the petition date versus what the debtor might have had before the petition date for the majority of that 180-day period. And Judge Kaplan was pretty open in his decision. He acknowledged that this test and frankly the breadth of the statute generally makes venues subject to manipulation. That's certainly no surprise, again, to anybody who practices in the bankruptcy court. But he also noted, and I think it gave him some comfort, that the court can transfer a case for the convenience of the parties and in the interest of justice to prevent abuse. So with that out and the ability to exercise discretion, I think overall, Judge Kaplan was comfortable that the asset-based approach was the right approach here. So ultimately, not to bury the lead, Judge Kaplan held that the accounts in the New Jersey bank accounts that Norwood held were that entity's principal assets. Venue was proper because those assets were in New Jersey for 16 days, which was longer than any other assets in any other district, at least with respect to this entity. I think it's important to note that the movements did argue that MCC Norwood had other assets that should have been their principal assets. And I think that this highlights the qualitative and quantitative analysis that the asset-based approach requires. So first, the movements noted that there were patents, that MCC Norwood had patents, that those were principal assets. And the judge basically said, look, I understand that there are patents here. There's no evidence about value. Value is not determinative in and of itself. But regardless, there was no evidence on the record demonstrating that the patents in and of themselves were more important or influential or consequential than the more than $1 million in the New Jersey bank accounts that the debtors absolutely needed to make their adequate assurance payments. Second asset that I thought was interesting were intercompany balances. Now, MCC Norwood was a dormant entity. I believe it was formed years back to acquire a facility in Ohio that ultimately closed, and it had been dormant, I think, for 2 or 3 years preceding the petition date. But there were some intercompany balances on the debtors' books and records. The debtors argued that those should have been eliminated, and the court basically said that bookkeeping artifacts was how he framed these, could not rise to the level of principal assets, particularly where they were never intended to be enforced, they were never going to be collected, basically just an accounting error or holdover from an earlier time. And third, which I thought was clever and creative, the movements pointed to D&O policies. The debtors had shared coverage, as debtors often do. And the court said that, look, sure, there are insurance policies here, but it's contingent, it's theoretical coverage only. It doesn't increase the worth of this entity. The entity has been dormant. There are no pending claims, so it's unlikely that this is really going to rise to the level of principal assets. So we wanted to include, as the last slide here, what the court noted is the gut check factor, which I thought was interesting. Judge Kaplan acknowledges that the Norwood accounts were funded for purposes of creating venue in New Jersey. Again, this is not a secret. This is, debtors do this all the time, but I think it's quite powerful having this acknowledged and admitted in a decision. And maybe it doesn't sit right. And I think Judge Kaplan indicates that maybe it shouldn't sit right. But this decision, as opposed, in addition to being a well-reasoned decision on venue and what courts look at, is also, I think, an exercise of judicial restraint. Everybody knows that this is something that happens. And if it is an issue, it's really up for Congress to act. And the court is quite clear. And I think that this sends a signal that if Congress does want to act, here's the roadmap. Here's what debtors do, and now it's up to you to amend the statutes and more narrowly tailor the venue requirements. Interestingly, on the record of yesterday's hearing, counsel for the lenders indicated that they indicated they intended to appeal the venue decision. I didn't see a notice of appeal hit the docket just yet. I might have missed that while we were.
It hadn't hit as of an hour ago, but things move fast, so I'm not sure.
Yeah, so we're keeping an eye, so stay tuned on that. And the other thing that's important to note here is, despite all the fireworks, the parties are all in mediation, and that mediation has been extended to the end of the month. So it could very well be that all of this ultimately gets resolved. But again, I think even if it does, we have a written decision on venue. I think it serves as a roadmap to parties who are thinking about this and thinking about venue in the future. And it also is an invitation, perhaps, to Congress to revisit some of these issues and act on amending the statute.
All right. So speaking of Congress, our next question, do you think Congress will change the bankruptcy venue rules? Yes, no chance, 50-50. Give everyone a minute to answer. I remember it must have been 3-4 years back now, but Sorrento Therapeutics, it was a similar venue dispute in Texas. And I think it was established there that I think opening a post office box like 100 days before the case counted as having venue. And that was, very contentious as well. And that was, down in the Fifth Circuit. So it continues to be, an issue. All right, to keep things moving along, we'll 89.3%, no chance. People have spoken. I tend to agree. Let's move on now to Serta. I could have brought this up at any time since 2020, and people would know what I mean when I say Serta. I won't go into the whole history, but the up-tier bankruptcy and litigation have been in the news for years. Litigation is now back on remand at the bankruptcy court. I should note, back in January 2025, we did a webinar, myself and Markel, on where things stood in Serta. But let's get an update now. Mark H., can you give us your thoughts on where things stand now, please?
Sure. Thank you. And you kind of opened with where I was going to open, which is, why are we talking about Serta? This is 2020. And I assume a very familiar audience here. It's a classic up tier. It was really the first of the major up tiers. Under the documentation in the bank loans, a simple majority of lenders could permit priming indebtedness. And there was a pro rata provision that had been put into the bank debt. And now, pro rata provisions existed way, way before LMEs. It was actually the baseline in the bank loan market that you couldn't actually discriminate between particular holders of debt with respect to payouts or any sort of discriminatory treatment. That actually only started to change in the mid-2000s, when it became apparent that in at least the securities markets, you could have debtors monetize discounts on debt. And there was a kind of a groundswell. And I was at Citigroup at the time, and I was pretty involved in all of this. There's a groundswell to say, well, hey, why can't we just have a debtor be allowed to participate in an open market and buy its debt at a discount? It's a win-win. Whoever wants to sell can sell. If they don't want to sell, they don't have to sell. And it's not really something that prefers one creditor over another, because no one really expected at that time for an open market purchase to be used in the manner in which it started to be used in the early 2000s. Over time, it became boilerplate. It became standard in large cap term loan Bs, used for opportunistic buybacks and liability management in a traditional sense. And then you had your first full real up tier in Serta in 2020. Open market purchase was a lowercase term. It was never defined. Actually, the CRC, the Creditor Rights Coalition, submitted an amicus at the time of the Fifth Circuit appeal, arguing that what had happened in Serta was not an open market purchase. It didn't follow what the intent of the language was. And we were successful in that. The bankruptcy court, which had found it to be an open market purchase, was reversed. The Fifth Circuit sent it back on remand and reinvigorated the breach of contract claim on behalf of the effectively subordinated creditors. In addition to that, in terms of remanding and reinstating a breach of contract claim, I do want to highlight that the Fifth Circuit also rejected an indemnity claim that had been put into the plan on behalf of the participating or preferred lenders, had done so on an equal treatment basis and on a contingent reimbursement claim basis. And the preferred creditors had tried to get this indemnity put through as part of a settlement rather than just simply a plan indemnity. Which, there were some legs to that made some sense, that you could have a settlement and do things under a settlement that might be different than what could be done under just an ordinary plan. But the Fifth Circuit rejected that and basically elevated substance over form. I know we're going to be talking about third-party releases, but I actually think that this is one of the first cases which has very close to post-Purdue jurisprudence. It's the same underlying issue of label versus function. Was the plan reallocating litigation outcomes without consent? And the Fifth Circuit basically said no and sent it back. Since that time, we've had a lot of litigation, and we've also had documentation with respect to what are called Serta blockers. Again, most of the people on this call understand what a Serta blocker is. It's an anti-subordination provision, and it can have very, very strict terms, or it could have loose terms, but it's essentially a heightened consent to acquiesce to subordination, and whatever the requisite majority is can be a negotiated majority. Private credit tends to have better anti-subordination protections than BSLs, but that also is converging. You can have different terms on Serta blockers. You can have material exceptions for DIPs and rights of first refusal. You could have it limited only to all collateral or a material portion of collateral. You can have it as otherwise permitted by other debt documentation, or you could have lien subordination versus payment subordination. In all of these cases, these are ways of negotiating around what was now a Serta issue or an up-tier risk. So again, why do we care right now? Well, this is in court right now. The Fifth Circuit remanded it. The Supreme Court of the United States denied cert on the Fifth Circuit opinion back in November of 2025. And now it's at trial in the bankruptcy court. The closing arguments are due on the 23rd of March. There won't be a ruling from the bench, most likely, but we're looking at a potential damages claim coming out on in the first instance out of really a high-profile LME. And we don't know how damages will be calculated or whether any of the attempts by the participating lenders to avoid liability will be successful. As to that second part, they're seeking to say that a debt-for-debt exchange doesn't really trigger the pro rata provisions. That's an argument that had been argued at the lower bankruptcy court, didn't really make it up on appeal, and is so live again. I'll give you my own thoughts, which is that that's highly unlikely given the history of pro rata treatment and what that phrase is intended to mean. And also raise a couple other issues, including that the competing lender group, which was the excluded lender group, actually had tried to do a drop down and get preferential treatment. And it was only because they lost sour grapes that they're now able to sue. And a couple of other arguments that are related to liability as well. Not very clear that any of them will be very successful, but they're things to look at. But it's really on the damages side. The plaintiffs here are asking for $460 million. And their theory of damage is really mushed. You can look at it in terms of priority value transferred. And that's just a simple way of saying, in priority value transfers, what was taken. It measures the legal right that was taken away. Essentially, what would have happened if you had still had your first lien right and not been subordinated. A recovery differential, which is, what did it cost you? My debt was trading at X and now it's trading at Y. And that brings up issues of loss mitigation as well as interest and when to start calculating things. And then disgorgement, which is not actually being argued formally that what the participating lenders should have gotten should be turned back over, but is really kind of embedded in the whole measure of presenting damages here, saying, look, what you ended up getting is something that should end up being shared pro rata with us. And so it's a little bit mushed together. Serta is not a defendant here. They've been released. And so this is really a very clean LME damages case. And I think it will help to define participating lender liability risk going forward. Having run money, having been on the sell side and buy side, I can tell you that nothing concentrates the mind more clearly than having to write a check for liability. This is something that actually will affect how different market participants work. And there's not a good example of these things actually going to trial, having a verdict on damages. Seems likely that that's going to happen here. Whether those damages are high, low, or zero will affect how different creditor groups will behave and how aggressive they will be on non-pro rata transactions going forward. So for that, I'll turn it over in the interest of time as well. Most people here know about Serta, but follow it because how this case comes out and what is actually written at the bankruptcy court is going to have practical implications for money managers.
Thanks, Mark. I'll note we have one more question as we move toward our last topic, but with the measure of damages in the Serta remand trial. priority value transferred, recovery differential, disgorgement. There will be no damages on remand. I will emphasize that my team will be on the hearing on Monday, March 23rd for closing arguments. I think it's extremely unlikely we get a ruling that day, but we will cover the arguments, publish something, and follow up with a piece on the ruling itself. Stretching back briefly to Multicolor, one of our bankruptcy reporters confirmed that there's still been no notice of appeal filed. When there is, we will, of course, report on that. All right. Priority value transferred wins over recovery differential here. So let's move to our last topic, which is an update on third-party releases. So some background, 2024, U.S. Supreme Court rules in the case, Chapter 11 case of Purdue Pharma, that non-consensual releases are not permitted in bankruptcy. Vacates the order confirming the plan, sends the case back to bankruptcy court. Great, provides some clarity. Then goes on to raise perhaps more questions than it answered. Debtors and lenders have pushed, well, primarily it raises the issue, what constitutes consent in a plan? In the 21 months since the court's ruling, debtors and lenders have pushed for opt-out release provisions, meaning that unless a creditor affirmatively checks a box and returns the form, the creditor will be deemed to have released any claims they may hold against non-debtor third parties. U.S. trustees' representatives instead push for opt-in provisions, meaning that creditors will keep claims they may have against third parties unless they affirmatively opt into giving such a release. Different courts have handled these differently. In Southern District of Texas, opt-outs are the standard. When on confirmation hearings in those cases, there have been times when they skip argument entirely. The U.S. trustee makes note of their objection, and then the judge overrules it. But we had some action late last year in the Southern District of New York where Judge Cote ruled in the case of Goal in favor of the U.S. trustees' opt-in arguments. That, of course, does not end things. In Delaware, Judge Lori Silverstein critiqued Judge Cote's decision as, quote, conclusory and described it as not meant to persuade, but to rule on a, quote, again, developing area of law. Other Delaware judges have preferred opt-ins or hybrid provisions, allowing opt-outs for voting creditors, but requiring an opt-in for non-voting creditors. Last month, in the case of the Catholic Diocese of Buffalo, New York, in the Western District of New York, Judge Buckey ordered the debtor to rework the plan to require creditors to expressly opt in to a third-party release. That is a mass tort case. These things tend to be handled a little bit differently, and we won't go into it, but it is interesting to have a new ruling from a new district. I will highlight some of the cases we have here. We put out on the bankruptcy team a regular third-party watch list that looks at what releases are in cases confirmed over the past few months. Here we have January 2026 to present. I'd like to go now to both Marks for some thoughts on the state of third-party releases. Mark H., what are you thinking on how things have developed recently and where it might be going?
Well, we really have three different polls here. We have the opt-in, opt-out, and then let's focus on the process. Let's look at notice, sophistication, and process integrity. I think about this, if you're personally, a lot about whether you're subjecting yourself to the court's equitable jurisdiction by participating in the case. And to me, that's my old school touchstone here. Filing a claim, appearing, doing anything in the case that's affirmative has traditionally allowed the court to basically say, I can make you do something that you otherwise wouldn't want to do. You subjected yourself to the jurisdiction. And I personally think the cases that are leaning in that direction are probably where the center will hold. That if you actually are participating in a case, it's not simply silence equaling consent, but that there is something that's not necessarily express consent to the release. The court will have the jurisdiction to have an opt-out for you. Say, if you receive proper notice, if you have sophistication enough to understand that notice, you can be bound. My own view is that bankruptcy has always acted as a safety valve for class actions, tort claimants, dealing with sponsor contributions and insurance type of contributions. And that's a very valuable policy contribution that bankruptcy courts offer to the litigation universe. There are ways that you can't get around what Purdue has said. There are reasons why you wouldn't want to get around what Purdue has said. But to the extent that someone actually can show up in court, I think the courts are going to resolve toward opt out, reasonable notice for those who have actually touched the courts. And that series of cases is where I think the law is going to move.
And Mark Lightner, I wanted to ask you briefly about potential SCOTUS case in Highland Capital Management, not third-party releases entirely, but specifically exculpation. Some thoughts on that?
Sure, and we'll close on this thought, which is, for those of you that read the Purdue Pharma decision, there was a quarrel between Justice Kavanaugh in the dissent and Justice Gorsuch in the minority, and Justice Kavanaugh basically said in no uncertain terms that the court's ruling was going to throw into doubt all kinds of other mechanics that we use in bankruptcy process, including exculpation clauses. And Justice Gorsuch basically said, no, this decision we're deciding on our facts. It shouldn't be read more broadly than that. And as Pat mentioned, raised a whole bunch of questions that were left unanswered. It's almost like the Supreme Court Full Employment Act for appellate lawyers. It listed a whole list of potential issues that the court would be happy to address in a future case. And one of those happens to be exculpation. And in the Highland Capital case in the Fifth Circuit, and I know we're closing in on time here, the Fifth Circuit took a very narrow view in terms of what is allowed in terms of exculpation. And exculpation, for those of you that don't know, although I suspect most people do at this point, since if you're still listening to us, you're probably a hardcore bankruptcy fan, it effectively serves as a release for individuals that actively participate in connection with the Chapter 11 process, and we don't want to hold those people or give them exposure from activities during the bankruptcy process. And the Fifth Circuit took a very narrow view in contrast to what a lot of other circuits have done. That issue is currently before the Supreme Court. It is fully briefed. Interestingly, the Supreme Court has asked the Solicitor General to weigh in on that. They asked the SG to do that back in October. It's been 5 months, so I expect the Solicitor General, subject to the continuing government shutdown, to file a brief in this case imminently, literally any day now. And so what the SG says, I think will say a lot about whether the Supreme Court will take the case. If they do take the case, at least for bankruptcy practitioners and people who play in the restructuring community, this will be the hot topic case for the next Supreme Court term. So while we talked about Purdue a year and a half ago, this may be the case that we talk about going forward to the extent they grant cert. So put it on your radar. It's going to be a big deal if they do in fact go this direction. So Purdue 2.0 may be on the horizon.
Thanks, Mark, and thanks everyone else. I think we'll close it out there as we are approaching an hour and 10 minutes. We had some questions we will answer personally offline today or tomorrow. I want to thank you to everyone who joined us today. I'll note the webinar will be available on YouTube in the next 24 hours. Thank you to Raf and Mark for joining us, along with my colleagues Ian and Mark. Goodbye, everyone. We'll see you next time.